72nd District Court, mock trial in session, presiding Judge Honorable Elwood Brown.
Be seated, please. Good afternoon. After everybody's eaten, you're not falling asleep, are you? No, are you? Well, I want to welcome you to the third stage, I guess I'll call it, of the mock trial of this year. This is the fourth year that we've done this, and we certainly do appreciate all the volunteers that we have that are working here, the lawyers and the St. Clair County Bar Association, the sheriff and his crew that have come in and volunteered their time to be with us and help you in this participation as well. And I want to thank all of you as well for showing some interest in this, working hard to get to this day and working your way through all the nerves that I'm sure you all have. Before we go too much farther, I'm going to allow some people who are participating here to identify themselves and their background, and I'm going to start with the sheriff, Tim Donelon.
I am Sheriff Tim Donelon. I've been with the Sheriff's Office 21 years next week, and I just want to say congratulations and thank you for all the work you put through for the kids and the coaches. We don't always get to see the kids into their best light sometimes at work by virtue of our positions, and it is so refreshing to see the best of the young kids. Every year the Sheriff's Office provides the bailiffs, and every year I have a long waiting list of deputy sheriffs that want to come on their Saturdays to get exposed to the future generations of the great kids. So good luck this afternoon. I know everybody's going to do a wonderful job.
Thank you, Sheriff. And the lawyers that are involved in here, I'm going to let them introduce themselves and tell you a little about them, and we'll begin with Cindy Lane.
Thank you. My name is Cynthia Lane. I am a lawyer in private practice. I've been doing trial work for 29 years. This is my 29th year in the practice of trial law. And this is my 4th year participating in the mock trial program. I was a judge, I've been a judge for 2 years, and I was a coach at the very beginning. So I know very well what all of you are going through, and good luck.
Greg Stromers.
Welcome, everyone. Congratulations just being to this point, because I know it's a lot of work. I'm a civil attorney. I've been practicing for about 15 years. I tried my very first case right in this courtroom right here, so I kind of know what you're going through. So good luck, and I look forward to seeing your presentation.
Mona Armstrong.
Good afternoon. My name is Mona Armstrong. I'm a senior assistant prosecutor here in St. Clair County, and I've been a lawyer for about 15 years, and the vast majority of that I've done trial work pretty much on a daily basis. So I know what it takes to get to this point. I know that the most important part of a trial is the preparation, and from what we've seen today, there's been a whole lot of it, and I appreciate the effort and the hard work that you've all put forth so far, and I'm excited to see what you're going to do today. Good luck.
David Keys.
Thank you, Your Honor. My name is David Keys. I am a partner in a Port Huron law firm. I have been practicing for 19 years, and I litigate civil cases.
And Mark Davidson.
Good afternoon. My name is Mark Davidson. I'm a senior partner in the firm of Hill Dievendorf here in Port Huron. I'm a civil litigator also. I get to be the senior guy because I've been at it over 30 years now. But it's if you get around civil litigation, you know, probably 90-95% of the cases do get settled. But you know, if any of you do go on to law school and become lawyers, as I hope you're all going to do, you know, being able to sit here and know how to interrogate witnesses is a wonderful skill to have, because you never know that the case you have may not get settled. So again, congratulations for being here today, and good luck in your competition.
Thank you, judges. And as Sheriff Donelon mentioned as we came out, my name is Elwood Brown. I'm a sitting judge here in this county. I'm a probate judge, but I really don't do any probate work anymore. I do pretty much all family court. So I handle cases involving abuse and neglect and juvenile delinquency and divorce. I have been a judge now in my 10th year. Previous to that, I was the St. Clair County prosecuting attorney, and previous to that, I was an assistant prosecuting attorney. So I've in my 30th year as a lawyer. Most of my time is pretty much all of my time other than the preparation has been spent in the courtroom. So it's been a big part of my life, what you're doing here, as far as presenting evidence, listening to evidence, making decisions, and cross-examining witnesses and things of that nature. Also arguing to juries. Being a lawyer, especially a trial lawyer, is more of an art sometimes than anything else. So I'm excited to see you here. I'm anxious to see your performance here today and how well you've prepared and how well you tackle the various problems that you have been chosen to take on. So without anything further, at this time, I'm going to call the case of Young versus Gardner and ask if the parties are ready to proceed.
Plaintiff is ready to proceed, Your Honor.
Defense is ready.
All right, would the attorneys for the plaintiff please place their appearances on the record?
Your Honor, my name is Colby Alexis, and I represent Sidney Young.
My name is Shelby Chisholm, and I also represent Sidney Young. I'm Cassie Deanda, and I also represent Sidney Young.
All right, for the defense?
My name is Sarah Roosh, and I'm representing Riley Gardner.
My name is Ann Rushton, and I am representing Riley Gardner.
My name is Matthew Bissing, and I'm also representing Riley Gardner.
All right, thank you. Is the plaintiff ready to give their opening statement?
We are, Your Honor.
Go ahead.
I would like to ask for permission to be able to move the podium and also move about the courtroom within reason.
Can't move the podium because it's wired.
All right.
I'll
We'll
allow
let
you to move about the courtroom so long as you don't approach the jury.
Thank you. May it please the court, ladies and gentlemen of the jury, Your Honor, my name is Colby Alexis, and I'm here today with my co-counselors, Cassie Deanda and Shelby Chisholm, to stand up for a young lady whose hopes and dreams were crushed by the negligent acts of someone who she had thought of as a friend. This case is one of negligence and tragedy. Miss Young was simply invited to go out to eat with a few friends at the end of a party when the defendant Riley Gardner's negligence while driving caused an accident that would change poor Sidney's life forever. While driving his car early on the morning of May 12, 2007, Riley was texting, speeding, and not paying attention to what he was doing. Because of his lack of due care, he lost control of his car, skidded off the road, and crashed into a utility pole. This crash resulted in severe and permanent injuries to Miss Sidney Young's right arm. Today, you're going to hear from 3 witnesses that will tell you what happened, and they're going to show you, through their testimony, that Riley Gardner is negligent, and that his negligence was the proximate cause of Sidney's injuries. The first person you're going to hear from today is Sidney Young. Sidney Young is going to tell you about Riley's texting while driving. She's going to tell you that Riley was driving at least 10 miles an hour over the speed limit before the crash. And then Ms. Young is going to tell you about the injuries she sustained and how they are serious and permanent and are going to cause her pain, suffering, and the inability to do many activities for the rest of her life. Next, you will hear from Evan Simpson, an inadvertent witness to this accident. He's going to testify to the actions taken by Riley while driving. He's going to tell you that he saw Riley's vehicle speeding moments before the crash. He's going to tell you that he saw the faint green glow of a cell phone in Riley's cab just before the crash. And then, ladies and gentlemen, Mr. Simpson is going to tell you that he did not see Riley Gardner look up once before he crashed his car. The last witness you're going to hear from, ladies and gentlemen, is Peyton Lancaster, a professional accident reconstructionist who has been working on cases just like this one for over 4 years. Mr. Lancaster is going to tell you just how far above the speed limit Mr. Gardner was traveling when he crashed. He'll tell you about the effect that text messaging has on teenagers while they drive. And he's going to tell you that he's in agreement that the text messages sent from Riley Gardner's cell phone, the dates and times of those coincide with the date and time of the crash when Sidney injured her arm. As the plaintiff in this case, we have the burden of proof, which means we must prove to you by a preponderance of the evidence that Riley Gardner was negligent and that his negligence was the reason that Sidney was injured. Ladies and gentlemen, we are going to meet those expectations, and we are going to prove to you that Riley Gardner was negligent, and you will see and I am confident that you will see what I see in the evidence, and that you will find Riley Gardner negligent and at fault for my client's injuries, and that you will award her the money she is owed by the defendant for the damage she has done to her. Thank you.
Does the defense wish to give their opening now or reserve it till later?
Yes, Your Honor.
Go ahead.
Good afternoon, Your Honor, and ladies and gentlemen of the jury. My name is Ann Rushton, and joining me today on the defense are Sarah Roosh and Matt Wissing. Today, we are representing Riley Gardner. First off, let me remind you that as the defense, we do not have the burden of proof. The burden of proof lies with the plaintiff. They must prove that Riley was negligent in the ways claimed, and that Riley's negligence was the cause of the plaintiff's injury. However, we feel that the evidence will show that that Sydney was comparatively negligent, failing to use proper caution for her own safety. If her fault is determined to be 50% or more, she will be barred from any recovery. If it is found to be less than 50%, any award to her must be reduced accordingly. But the evidence will show that Riley Gardner is a responsible high school student who was just trying to do the right thing. On May 11th, 2007, a student had a party to celebrate a major win for the high school's baseball team. At the party, people were drinking, but Riley was not one of them because she had an alcoholic father who died when he was drinking and driving. Around 12:30 a.m., Riley decided she wanted to leave. She suggested to a few people, specifically Sydney, who was clearly intoxicated, that she should come get some food, hoping it would help the alcohol metabolize faster. Riley, the plaintiff, and Alex Williams got into Riley's new car to drive to the nearby White Castle. Before leaving the driveway, Riley told them to buckle up. You will hear testimony from Alex that while he did have his seatbelt on, he saw Sydney take hers off. Now, Riley's car was new, and there were some things she was getting used to, so she was being extra cautious that night. On Wellsgate Parkway, south of Fisk Avenue, something happened, and we can't be sure what. But it caused Riley to lose control of her car, hit a curb, and run into a telephone pole. Now, Riley did also send a text that night before the accident. We won't try to deny that. But she gave the phone to Sydney before the crash. Riley and Alex, who had their seatbelts on, were unhurt and able to exit the car. Unfortunately, Sydney was not. Officer Knight, an expert in accident investigation, arrived on the scene and spoke with the EMTs. He then started gathering evidence and interviewing witnesses. Later at the hospital, blood tests were given and showed that while there was no alcohol measured in Riley's bloodstream, Sydney, who was 18 at the time, had a blood alcohol level of 0.09, which is legally intoxicated. But the evidence will also show that Sydney was not wearing a seatbelt, and that Officer Knight will testify that the car was going 5 miles per hour under the speed limit, and that speed was not a contributing factor in this crash. Now, Riley is sorry that Sydney was hurt. She really is. If she could change what happened that night, she would. She did not intend for anyone to get hurt when they left to go get that food. And the evidence will show that Riley was not negligent, but trying to do the responsible thing and take care of the plaintiff, who was drunk. So what would have been seen as the right, responsible thing to do if there hadn't been an accident is being brought to the court as a case for negligence. But the evidence will show that the accident was not caused by texting, speeding, or drunk driving, but by some other factor that we may never know for sure. Thank you.
All right, plaintiff may call their first witness.
I'd like to call Sydney Young to the stand.
Raise your right hand, please.
Can I raise my left?
Go ahead. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Be seated, please.
Good afternoon. Will you please state your name for the record?
Sydney Young.
And how old are you?
I'm 18.
Where do you live?
I live in Clearwater Superior.
And are you in high school?
Yes.
What grade are you in?
I'm a senior.
Where were you at the evening of May 11th, 2007?
I was at a sporting event after party at Austin Kramer's house.
What happened at this party?
Everyday party. There was swimming going on and everybody just hanging out.
Did you know anyone there?
Yes, I knew Riley Gardner and Alex Williams.
How did you know them?
Alex, I've been seeing him at other parties I've been to, and I've been getting to know Riley through school. We've also hung out some more. I've been getting to know her.
Did you leave the party?
Yes, I was getting hungry, and we just decided to go to White Castle.
Who suggested this?
Riley did.
And did Riley invite you into her vehicle?
Yes.
And Riley was driving?
Yes.
What happened during the drive?
Riley was starting to scare me because she wasn't paying attention to the road, and she was pretty locked on her cell phone. She was making me very nervous by the speed that she was going. Also, she was going faster than I could think, and it was very scaring me.
Was Riley texting during this drive?
Objection, Your Honor, leading question.
Response?
The witness may answer yes or no. I'm simply asking whether Riley was texting.
Rule.
Was Riley texting during this drive?
Earlier, yes.
Did Riley seem distracted by these texts?
Yes, very much so.
Do you know who Riley was texting?
Her boyfriend, Taylor.
And how long was Riley distracted by these texts?
Almost the whole entire time, pretty much the whole entire time.
So, before the crash, was Riley texting?
Yes, I believe so.
How long?
Pretty much all the time before up until the crash.
So do you remember the accident?
Yes.
What happened?
Riley was speeding very much so, and she wasn't paying attention to the road. And all of a sudden, I saw the phone fly at me, and we crashed.
Which side of the vehicle was hit?
The right side.
Which side were you sitting on?
The right side.
Did the car crashing into the pole affect the side of the car that Riley and Alex were seated on?
No.
Was there any way you could have avoided being hurt in this accident?
I believe so, no.
It's been stipulated that you were injured, but what were the extent of your injuries?
My right hand and arm have been hurt severely bad. My right leg has been injured. I cracked 3 ribs, and I cannot sit for long periods of time because it will ache throughout my whole body, and I get headaches very, very easily.
Will these injuries be with you forever?
Yes.
Do these injuries affect the profession that you wish to pursue?
Very much so.
Which profession is this?
I wanted to be an artist or a cartoonist.
Will you ever be able to become a cartoonist?
Unfortunately, no.
Why is this?
Because besides the fact that my right hand is my dominant hand, which affects my drawing right there and then, but also I cannot sit to draw the drawings that I would want to because it hurts.
I have a few final questions. Did you believe Riley to be under the influence that night?
No, I did hear rumors after the fact, though.
And if you had thought Riley was impaired, would you have ever gotten to the vehicle with her?
Not at all.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor.
You claim you heard about Riley drinking after the party, correct?
Yes.
But you had been drinking at the party.
Yes.
And isn't the legal drinking age in Superior 21?
Yes, but I did not see no harm to it because I didn't plan on driving. I didn't.
But you were 18 at the time, correct?
Correct.
Which is under the legal drinking age?
Yes.
You remember what the paramedics said as they pulled you out of the car, correct?
Yes.
You heard one of them say, "This one smells like the bottom of a
Objection,
keg"?
Your Honor, hearsay.
Your Honor, when the paramedics said this, it was a present sense impression.
What's your response to that?
I'm not sure what a present sense impression is.
Okay. The objection sustained.
Thank you, Your Honor.
But you had also heard one of them ask you how much you had had to drink, correct?
Yes.
You claim Riley sent you a comment on MySpace, isn't that true?
Correct. I was very disgusted by it.
And so you deleted the comment, correct?
Yes, I did not want to see it anymore.
So you have no independent support that the comment existed in the first place?
Correct. I did not like it.
Riley told you to buckle up before she pulled out of the driveway, correct?
Yes.
But you have no proof that you were buckled up correct?
I believe that I was buckled up, yes.
But you have no proof.
No proof? Sure.
No further questions, Your Honor.
Redirect.
Not at this time, Your Honor.
All right, you may step down.
Thank you.
Next witness.
Plaintiff calls Evan Simpson to the stand.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Be seated, please.
Please state your name and age for the record.
I am Evan Simpson, and I'm 37.
On the evening of May 11th, what were you doing?
I was at my friend Joe's house. We were watching old American Idol reruns when Justin and Kelly were battling it out.
And did you stay home that night?
No, after watching a couple old episodes, we decided to have a different kind of fun and go buy some lottery tickets.
Did you drive?
No, my car was in the shop, so we took Joe's old van. He calls her Licorice.
Do you have a license?
Yes, for 21 years.
Right. So, you would say that you have the ability to tell if a car is speeding or not?
Yeah, 21 years of driving gives you that ability, I'd say.
Right. And you said you didn't drive, so where'd you sit in Joe's car?
I sat in the passenger seat.
What kind of a passenger are you?
I'm a really bad backseat driver.
Could you very briefly elaborate on that?
You do all the normal things a driver would do, like as you're passing an intersection, you look both ways to make sure no cars are coming, and stuff of that sort.
Alright, so on that evening, when you were backseat driving, did you see anything out of the ordinary?
Yes, as we're on Pitt Avenue, we saw a car coming southbound, and happened to be Miss Gardner's car, and I could see a green glow inside, and from a cell phone, and her head was down the whole time.
Alright, and what did you see next?
As we passed the intersection, we saw their car crash into a utility pole behind us.
Alright, did you stop and help them?
No, I thought calling EMS would be a better way to help them because we'd just get in the way if we were there.
Alright, and one more question, Mr. Simpson. Do you get anything today for testifying?
No, I do not.
No further questions?
Cross-examination.
Yes, Your Honor. Your Honor, may I approach the bench to show you what has been previously marked as exhibit number 3?
What is exhibit number 3?
It's the conviction of it.
You don't need to approach the bench. Show it to your opposing counsel.
Right.
May I approach the witness, Your Honor?
With the exhibit?
Yes.
Go ahead.
I'm now handing you as previously marked exhibit number 3. Could you please identify it?
Good to have you speak up a little bit, though, so microphones will pick you up, please.
Okay, well, it appears to be a court report about my embezzlement case.
Your Honor, we offer exhibit number 3 into evidence this time. The authenticity of the exhibit has been stipulated previously.
Your Honor, lack of proper foundation, I do not know what this is.
Want to show it to the opposing counsel again?
Your Honor, I don't see where this is relevant to this case at all.
Well, the pretrial statement involved a stipulation involving the judgment form of Evan Simpson as it relates to his conviction, so it's been decided that it is admissible. And the witnesses identified it as the correct conviction record of him, so I'm going to admit the evidence. However, the witness can't testify from it. You need to retrieve it, please, from the witness.
Okay. The person that you embezzled from was your grandmother, correct?
Objection, Your Honor, relevance.
Your Honor, this shows credibility of the witness.
Mr. Simpson is not on trial today. He's a witness to this. He does not know anybody involved in the accident.
His credibility is still important.
The facts contained in the previous case with relation to this particular witness is not admissible as it relates to credibility or anything else. The fact of the conviction can be used for that purpose, but the underlying facts behind the conviction is not relevant.
Right. You were convicted of embezzlement, though, correct?
Yes.
You had worked a double shift that evening, hadn't you?
Yes, I did.
So it would have been reasonable to assume that you were tired?
Maybe a little bit.
So this car was coming at you, and you were looking directly into its headlights, correct?
Well, you can cover up the headlights and still see inside a car.
So, but it would have been difficult to see in the car, right?
Well, because I had eye surgery a couple years ago, so my eyes are better than a normal person's, and that would allow me to see into the car easier.
You said that you saw a faint green glow in your statement that resembled a cell phone, or looked like a cell phone, correct?
Yes, I did.
Is it unreasonable to assume it could have been something else, such as a glare, or dash lights?
But why would a driver stare constantly down at those things? I mean, those things would take maybe a split second to change or turn
That's
on.
not what I asked you.
Can you repeat the question again? I'm sorry.
Wouldn't it have been reasonable to assume that this glow was from something else, such as dash lights or a glare?
Well, I wouldn't say reasonable because he is staring down at it, and you still would not stare down at like turn signals or anything else except a cell phone.
Don't you look at your speedometer when you drive?
But you don't stare at it, you're supposed to look at the road.
But you'd be looking down.
But you wouldn't be looking down for that long at your speed. It's
You noticed that the pavement was wet that night, didn't you?
It was a little bit wet from the sprinkler systems.
Right. And you never actually saw the car crash, did you?
Well, I saw it crash behind us, actually.
In your statement, it says you didn't see it crash. You only saw the crash after the fact.
Well, how did I call the EMS without seeing a crash? It seems kind of odd.
But you didn't actually see it happen.
Oh, it happened? Okay, sure.
Thank you for the question.
Redirect.
No, Your Honor, not at this time.
All right, you may step down. Witness.
Plaintiff called Peyton Lancaster to the stand.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Be seated, please.
Can you please state your name and occupation for the court?
Peyton Lancaster. I'm an accident reconstructionist.
And what kind of work do you do as an accident reconstructionist?
I do a lot of things. I collect, measure, photograph, record, and evaluate physical evidence I find on the road, the environment, other vehicles, and I use all this data to decide how a collision occurred.
And what kind of post-secondary schooling have you received, Mr. Lancaster?
Well, I received my bachelor's degree from University of Superior and my Master of Science degree from Superior State University.
What kind of training do you have to receive to become an accident reconstructionist?
Well, in order to be accredited by the ACRTA, which is the accredited coalition for the reconstruction of traffic accidents, one has to undergo a very rigorous exam, and usually one fails the first 1 or 2 times.
But you did pass that exam.
Objection, Your Honor. Unfair extrapolation.
What's your response?
Unfair extrapolation to what?
Well, wait a minute. You have to talk to me. Okay.
Sorry, Your Honor. I don't know what this unfair extrapolation charge is
What are you
relating to.
claiming is unfairly extrapolated?
That it is normal to fail your first 1 or 2 times.
Your Honor, my witness took this examination and knows several people, I would assume, that has taken this examination.
An
Would not.
objection for unfair extrapolation, you need to point out to me in the materials, if you can find them, where this answer is supported.
Your Honor, I cannot find where in the statement it says that the examination has failed most of the time.
And the objection is sustained.
Thank you, Your Honor.
Mr. Lancaster, have you ever testified in court as an expert?
No, but I've given my deposition 3 times.
Do you think that your examination, withdrawn, Your Honor, did you reconstruct the accident that we are litigating in this case, the one that occurred on Wellsgate Parkway on May 12, 2007?
Yes.
And what did you learn from your reconstruction of this accident?
Well, according to my calculations, the defendant was actually going 8 miles per hour, at least 8 miles per hour above the speed limit.
And did you take the measurements that you used to create this data?
No, I got a very able and well-trained coworker to go collect the measurements for me. I told him exactly what to measure.
And you trusted this data?
Yes.
Have you ever studied the effects that text messaging has on teenage drivers?
Yes, I actually just underwent a study just like that. According to my study, teens that text while driving spend 400% more time with their eyes off the road than while they're not texting.
No further questions, Your Honor.
Cross-examination?
Yes, sir. So, as an accident reconstructionist, you specialize in rollovers, correct?
Yes, most of the time.
And this was not a rollover accident, was it?
No, it was not.
And you're being paid to testify today, correct?
A very reasonable sum. My time is very in demand.
And that you're charging $250 an hour.
Yes.
Objection, Your Honor, relevance?
It shows a bias to testify here today.
This is overruled.
Thank you, Your Honor.
Thank you, Your Honor.
I'm not being paid to lie.
But you almost always testify for the plaintiff, correct?
Objection, Your Honor, relevance again?
Again, it goes to show a bias.
Your Honor, who my client testifies, or who my witness testifies for, does not show a bias.
The objection is overruled.
Thank you.
Thank you, Your Honor.
So, you almost always testify for the plaintiff, correct?
Most of the time, but not always.
And the reason you were rejected twice for accreditation was because you could not pass the practical portion of the test, correct?
Which was under a time constraint.
And you never went to the scene of the accident.
I didn't have to in this case.
You didn't, in your, never mind. You never saw the tires, did you?
I couldn't because your detective threw it away.
But you feel that their condition was not a factor in this case, correct?
No, I don't.
Do you remember making a statement in this trial?
Yes, I believe so.
In that statement, didn't you say that, I believe the tire which was flat on the right front wheel was fully functional at the time of the crash?
Well, if you just read out my statement, I must have.
And their condition could have affected your calculations, correct?
Yeah, one must consider the tires when doing these calculations. That's correct.
And you were not able to use them.
No, I was not.
You used the witness statements, accident reports, and measurements taken by law enforcement also, correct?
Yes. And from them, I was able to deduce that the defendant was speeding. I'm quite sure he was speeding.
But you also did not measure any skid marks yourself.
I got a very able coworker to measure the skid marks. It wasn't necessary for me myself to measure them.
And you also testified earlier about publishing a study about texting while driving.
Yes.
And you have seen the text messages in this case.
Yes.
You have no opinion upon their effect in this case, do you?
I don't have a professional opinion.
Thank you. No further questions.
Read it right, Your Honor. Mr. Lancaster, you were able to observe the text messaging records of Miss Gardner in this case, is that right?
Yes, I was.
Right. And what were you able to determine upon your examination of those?
Well, from the text records, I'm in agreement that the times do seem to coincide with the accident.
Okay. How much are you paid for your services?
$250 an hour.
How many accident reconstructionists are there in the world, Mr. Lancaster?
In the U.S. and Japan, there's 650.
So with 650 accident reconstructionists in the United States and Japan, do you think that $250 is a reasonable amount to be paid?
Absolutely.
Objection. That calls for an opinion.
Your Honor, this is my witness's profession. I think he would know if it was a reasonable amount to be paid.
I'll overrule the objection.
Thank you, Your Honor. No further questions.
Let me step down. Any other witnesses?
The plaintiff rests, Your Honor.
Defense?
The defense calls Riley Gardner to the stand.
Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yep.
Is that a yes?
Yes.
Be seated, please.
Could you please state your name and age for the court?
I'm Riley Gardner and I'm 18.
Do you currently have a job?
Yes, I do. I have a paper out which I have to get done before school.
And why is that?
Well, after school I have to get home right away to babysit my 3 younger sisters.
So then how does that affect your job in the morning?
Well, it causes me to hurry a lot.
And has that had any negative consequences?
Unfortunately, yes. Because I do have to hurry, I've actually gotten 2 speeding tickets. But they're only going for about 10 miles over, and I'm sorry I've got them.
I want to call your attention to the night of May 11th, 2007. Can you tell the court anything interesting about that night?
Well, Austin decided to have an after party after our baseball team won district champs.
Could you tell us a little bit about the party?
Well, I mean, it seemed like a normal party, but I was beginning to feel uncomfortable there.
And why is that?
I noticed there were a few drunk people there.
And why did that make you feel uncomfortable?
Well, unfortunately, my father actually was an alcoholic, and, you know, my mother always tried him on the right path, but unfortunately he died in a car crash after he'd been drinking.
You said there were a few people making you uncomfortable because they were drinking. Was that anyone in particular?
Well, I noticed Sydney had been drinking a lot.
What happened next at the party?
Well, after a while, I started to think of a reason to leave because I was feeling uncomfortable, so I suggested to a few people that we should go to White Castle.
Did you have any other reasons for wanting to leave?
Well, I was waiting to hear from my boyfriend, Taylor, that we were supposed to meet in a coffee shop afterwards.
What happened after you suggested you go get something to eat?
Well, Sydney and Alex agreed to go with me, so we all got into my car.
Could you tell the court how everyone was sitting?
Well, Alex sat behind Sydney and I, and Sydney sat next to me in the front.
What happened after you got in the car?
Well, after we got in the car, I told everyone to buckle up, and then as soon as we were pulling out of the driveway, I received a text message from my boyfriend.
What did you do then?
Well, since I was in a new car and I was still uncomfortable, I wasn't used to, like, parking it, and since it was also at night, I was being extra careful, so I handed the phone over to Sydney and text no NTWD.
Which means?
No texting while driving.
Have you ever texted while driving before?
I have,
And why didn't you this time?
Well, like I said, I wasn't used to being in the Accord, and I just didn't want to take that chance.
What happened after you handed Sydney the phone?
Well, right after I handed Sydney the phone, I'm not sure what happened, but unfortunately I lost control of the car, and we ended up crashing into a telephone pole.
So you're not sure what caused the accident?
I mean, honestly, I really don't know, but I think like my front right tire must have blown out.
What happened after the accident?
Well, after the accident, Alex and I got out of the car, and during the investigation, I answered all their questions and I handed my cell phone over right away.
Had you had anything alcoholic to drink that night?
No.
Were you speeding while you were driving?
No.
Were you texting while you were driving?
No.
Objection, Your Honor, calls for a legal conclusion? I'm sorry. Calls for an opinion?
Your Honor, I'm not sure what he's saying calls for an opinion.
Overruled.
Thank you, Your Honor. Would you like me to repeat the last question?
Yes, please.
Were you texting while driving that night?
No.
No further questions, Your Honor.
Cross-examination?
You've received 2 speeding tickets in your driving history, is that correct?
Yes.
And you attended a party at Austin Kramer's house on the night of May 11th, 2007?
Yes.
And there was drinking at this party, right?
Yes.
And I believe you've stated already that you don't like to go to parties where there's not drinking. Or rather, had you known that they were going to be drinking at that party, you wouldn't have gone. Is that right?
Yes.
And yet, you say that you invited Sydney Young and Alex Williams, who you call partiers, into your car to go with you to get something to eat. Is that correct?
I thought that the food would help metabolize the alcohol that Sydney had been drinking.
Yet you still invited 2 people into your car that you said you didn't even want to be around.
When they were drinking, no, but I thought it would help.
You were not yet used to driving your 5-speed car that night of the accident, were you?
That's why I was being extra careful.
And you weren't even quite sure how to park your car, is that correct?
I mean, I'll admit I was a little not completely used to parking.
While you were driving with Alex and Sydney in your car, did you read a text message?
I received one when we were pulling out of the driveway, and I glanced at it, but right after I gave it to Sydney.
Are you aware, Miss Gardner, that according to the statute SCL 257.1234, it is against the law in the state of Superior to read, write, or send electronic messages while operating a motor vehicle?
Yes.
And yet, you still did it, correct?
Yes.
What side of the car, where was Sydney sitting in the car?
On the front right side.
And where was most of the damage done to your car?
The same side, the front right.
So Sydney's injuries were caused because she was sitting on the right front side of the car where most of the damage occurred when you crashed.
Yes.
Isn't it true, Miss Gardner, that you don't know what happened when you crashed your car?
Like I said, I thought my front tire must have run out.
You can't be sure of what happened when you crashed, is that right?
Yes.
And you have no proof that your right front tire caused the crash.
Yes.
And you have heard testimony from an expert accident reconstructionist that says that the right front tire of your car is not the reason you crashed, is that correct?
I can only give my opinion, but yes.
So isn't it true then that what you believed happened could very well be completely wrong?
Yes.
Thank you. No further questions.
Redirect.
Nothing, Sir, Your Honor.
You may step down. Next witness.
Defense calls Alex Williams to the stand.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Be seated, please.
Please state your name and age for the court.
My name is Alex Williams, and I am 17 years old.
And I would like to direct your attention to the night of May 11th, 2007, after 11 o'clock p.m. What did you do that night?
Well, I was at a party because our baseball team had beaten Cardin in the districts.
And what did you do while you were at this party?
Well, a couple people were swimming, but I decided to dance with this girl named Jessica. We sort of had a thing going.
And did you leave the party at all?
Yes, around 12:30, Riley suggested that we should go to White Castle and get some food.
And so, how did you get there?
Well, I didn't think it would be good for me to drive, and if I had to guess, Sydney was drunk, so Riley drove us there.
And how were you seated in the car?
Oh, I was sitting behind Riley, and Sydney was driving. Was in the passenger seat, front passenger seat.
And so, what happened once you got into the car?
Well, we backed out onto Fisk Avenue, and then we turned onto Wells Gate.
And so, what happened when you were doing this?
Well, Sydney had taken off her seatbelt to turn around and ask me a question or tell me something.
And what happened next?
Then this big black thing, like a shadow, came out in front of our car, and we swerved, and then we hit a pole.
And was anybody hurt?
Well, Riley and I got out of the car, but Sydney couldn't. I'm guessing because she wasn't wearing her seatbelt.
And was there anything else that happened on the way to White Castle?
Well, I saw Riley texting, but then she handed the phone to Sydney right before the crash.
And about how long between Riley giving the phone to Sydney and the crash was that?
About 10 seconds.
Thank you. No further questions.
Cross-examination?
Now, you say you were at a party that night, right?
Yes, I was.
And you brought about 8 beers to that party?
Objection, relevance.
Your Honor, the defense opened up the door today about drinking. I'm just clarifying that Mr. Williams was drinking, and that could go to his credibility, because he wasn't thinking clearly.
Just because he brought the alcohol does not mean he consumed any.
Your Honor, can I have some leeway? My next question was how many he drank.
Take your objection under advisement.
All right.
Thank you, Your Honor.
And you drank 3 to 4 of these beers?
I drank 3 or 4 beers while I was at the party.
All right. Are you aware of the drinking age? Just
Yes.
all right. And you said that Miss Gardner invited you and Sydney to go eat.
Yeah, she did. She invited us to go to White Castle with her.
All right. And you didn't drive though, correct?
No, I didn't.
Where did you sit in the car?
I was sitting behind Riley.
All right. So you were on the left side, right?
Yes.
All right. And you said that you were not the seatbelt police, right?
Yes, I'm not in charge of.
But you also
everyone's wearing
say
a
that
seatbelt.
Sydney took her seatbelt off and never put it back on.
I said she took it off to look at to ask me a question. I don't know if she put it on or not. It's not my responsibility.
All right. So you also said that you saw a shadow run across the road.
Well, it sort of got out in front of our car.
The road was well lit, correct?
Yes.
The car had headlights. They were on.
The headlights were on.
All right. But nobody else in the car has said anything about seeing the shadow.
I don't know if they did or not. We swerved not to hit it.
Are you sure about that? Are you sure that nobody else saw the shadow?
I don't know if anyone else saw the shadow. All I know is there was a shadow in front of our car and we swerved not to hit it. And then we hit a pole.
No further questions, Your Honor.
All right. You direct?
No, thank you, Your Honor.
You may step down.
Your Honor, the defense calls to hearing right.
Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Be seated, please.
Please state your name for the court.
Adrian Knight.
And what do you do for a living?
I am supervising officer for the City of Clearwater's Police Department.
Do you do anything in particular for the city of Clearwater?
I work all the major accidents in my jurisdiction.
What qualifications do you have for this job?
After going to a police academy in Georgia, I worked a few years with Madison County Sheriff's Department. I worked part-time security. I actually 4 years, for the last 4 years, I worked with the Superior Highway Patrol, and the last year I was there, I was usually the most experienced at the scene.
Did you take any additional classes?
Yes, I took a 5-day training session on accident reconstruction.
Why did you take this course?
because I knew that the knowledge that it was going to give me and the experience was going to help me in the future.
What, if any, campaigns are you involved in?
I have organized a campaign called Attention Equals Alive, and it is similar to Click It or Ticket or Just Say No. It's about driver inattention.
Your Honor, I move to introduce Officer Knight as an expert in accident investigation.
No, this has been stipulated too, so the plaintiff has no objection.
Court receiver testimony in the field of accident investigation is next.
Thank you. Let me direct your attention to the hour of 1 a.m. on the morning of May 12, 2007. Did anything unusual happen this morning?
Yes, I was called to examine a scene of a wreck.
Your Honor, may I approach the bench to show you what has been previously marked as Exhibit 1A and 1B?
What is 1A and 1B?
It's the accident report filed by Officer Knight.
You don't need to approach the bench.
Okay.
Go ahead.
Your Honor, may I approach the witness?
Yes.
I have handed you what has been previously marked as 1A and 1B. Could you please identify it for the court?
This is the accident report that I submitted.
At this time, Honor, I move to have it submitted into evidence. Its authenticity has been previously stipulated.
Objection.
No objection, John.
The exhibit is received.
Could you please describe to me what you saw when you arrived at the accident?
I saw a silver Honda Accord, one of the newer models, and it was crashed into a telephone pole.
Then what did you do?
The first thing I did was I talked to the EMTs that were there to make sure everything went according to protocol.
Did you do anything else after that?
Yes, I took measurements, I evaluated evidence, and I interviewed the witnesses.
What did you establish from these interviews?
They led me to understand the route that they took.
And what route did they take?
They took a right onto Wellsgate from Fisk.
Did you conduct any other investigations or interviews later?
Yes, later at the hospital, I interviewed Sydney Young.
What did Sydney say at the hospital?
Sydney claimed to have been wearing her seatbelt. She also said that she couldn't remember anything after pulling out of Fisk and pulling out of Austin's driveway onto Fisk. And then I did not think she was very reliable because she was on pain medication.
Were there any tests taken at the hospital?
Yes, there were blood alcohol content tests.
What were Riley's results?
Riley's, there was no measurable amount of alcohol.
And what were Sydney's results?
Sydney's was .09.
Your Honor, may I approach the bench to show you what has been previously marked as exhibit number 2?
What is exhibit number 2?
It's the text messages.
Right, you don't need to approach the bench, but you may proceed.
Your Honor, may I approach the witness?
Yes.
I've now handed you what has been previously stipulated as exhibit 2. Could you please identify it for the court?
These are the text messages from Riley Gardner's cell phone.
Your Honor, I now move to have this submitted as evidence. Its authenticity has been previously stipulated.
No objections, Your Honor.
The exhibit is received in evidence.
Regarding the last 2 text messages, what, if anything, did you establish from these?
The last text message was not by the same author as the previous ones.
And how did you establish this?
I established this because the grammar in the last one was completely perfect and the proper punctuation, and the previous messages was abbreviated and shortened.
Did you conduct any further investigations after this?
Yes, the skid marks showed me a lot of information.
And what was this information you deducted?
that showed me that at the time of the crash, the vehicle was going 5 miles per hour below the speed limit, and the driver was aware of being out of control at the time of the crash.
Thank you. No further questions. Your Honor, may I publish the exhibits to the jury? 1A, 1B, and 2.
Do you intend to use them in your cross-examination?
Yes, Your Honor.
No, then you may not.
Great, thank you.
You may cross-examine.
You didn't go to college, did you?
No.
So you don't have any engineering training at all?
Objection, relevance.
Engineering is one of the key things in accident reconstruction, and it goes to her credibility as her ability to reconstruct accidents.
Your Honor, her experience has already been stated. She's worked every single investigation under police she works for in accident reconstruction.
Although a witness has been stipulated as an expert in accident investigation, not accident reconstruction, the basis upon which she made her decisions is still challengeable. So I'm going to allow the witness to answer the question.
Thank you. So you don't have any engineering training?
No.
And your time at the police academy does not give you any accreditation with the ACRTA, correct?
Correct.
And so thus you are not an accredited accident reconstructionist, correct?
No, I'm not, but I've had lots of experience through my work in my jurisdiction.
As an investigator?
Yes.
You worked on Attention Equals Live, correct?
Mm-hmm. Yes.
And in your studies, is it true that you found that there has been a tremendous increase in the number of problems associated with young drivers being distracted by things such as cell phones and texting while driving?
Yes.
Is it also true that you have worked on only one other texting while driving case?
Yes.
You worked the scene of the accident that night, correct?
Yes.
And you wrote the uniform traffic report?
Yes.
Let the record reflect that I am showing opposing counsel what is marked, or what is the Exhibit 1A. There's Exhibit 2B and everything as well. And on this report, you wrote this, correct?
Yes.
Under roadway surface conditions, is it not true that you marked dry?
Yes, it is true.
And under roadway character profile, is it also true that you marked level?
That is true.
So the road was dry and level, correct?
Yes.
All right. And you arrived at the scene relatively quickly?
Within 10 minutes.
And you spoke to all of the occupants that evening, correct? Of the vehicle, sorry.
Not evening. In the morning.
In the morning, sorry. Both Riley Gardner and Alex Williams confirmed that the driver, Ms. Gardner, was texting while driving that night, correct? Or morning, excuse me.
Yes.
And do you have any proof that these texts were not from Riley?
The last one was not in this as the same author, but other than that, no.
Can you be sure that this was not the same author?
No.
You also spoke to Miss Sydney Young that evening, correct? In the morning.
Yes.
When you spoke to her, she was on a lot of pain medication, and she had just been through a car accident, correct?
Yes.
Did you ever give her a chance to tell you her side of the story when she wasn't on pain medication, or on another evening that wasn't?
No, I did not.
And Ms. Gardner was given a blood test that morning, correct?
Yes.
To determine her blood alcohol content?
Yes.
This test was administered at 3:45, correct?
Yes.
This was well over 2 hours after the accident occurred, correct?
Yes.
Going back to the accident scene, the car was smashed into a utility pole at its right front quadrant, or the passenger side door, correct?
Yes.
This door, after being crushed by this utility pole, was not able to be opened, correct?
Yes.
And the front tire was flat.
Yes.
However, you determined that this tire was not the cause of the accident, correct?
Correct.
And did you ever bother sending it to the lab?
No, I did not feel it was necessary.
And the skid marks that the tires left, they were 73 feet long, correct?
I don't know. I said several feet on the report.
So you didn't find it necessary to put the length of the skid marks on your traffic report?
No.
And you also don't remember what number you used to create your calculations for the speed the car was going that evening?
I'm sorry?
In your statement, you said that when you calculate the speed of the vehicle, you have to use the location and length of the skid marks, correct?
Yes.
So you don't know what number you used for those skid marks?
Not at the moment.
You did calculate that the car was moving at 30 miles per hour, though, correct?
Yes.
And the curb in that street was 7 inches tall, correct?
Correct.
And the pole was 4 feet from the street, correct?
Correct.
And based on the diagram you drew, the skid marks went across the intersection, correct?
Correct.
So you're saying that this car traveled through an intersection and with some distance on both sides, with its brakes on, hit and went over a 7-inch concrete curb, had its tire burst upon the impact, and still continue 4 more feet with enough force to crush the passenger side door, all at 30 miles per hour?
No, I think well, I'll let you respond first.
Well, it's just one question. I'm just restating the scene of the accident that we're talking about.
Overruled. The witness was laying the foundation for her question. I mean, the lawyer was laying the foundation for her question.
Would you like me to repeat it?
Yes, please.
So you're saying this car traveled a distance long enough to go through an intersection with distance on both sides, with its brakes on, leaving skid marks. It also went over a 7-inch concrete curb, had its tire burst upon that impact, and it still continued 4 more feet with enough force to crush the passenger side door so that it could not be opened.
It's the same question that I just ruled on. So, overruled. Go ahead.
With enough force to crush the passenger side door so that it could not be opened, all at 30 miles per hour.
I didn't say all of that, but I said some of it.
Is it not true that you testified to all of these things prior to answering this question?
Most of them, yes.
Thank you, Your Honor. No further questions.
Redirect?
No, Your Honor.
All right, you may step down.
Thank you.
Do you have any further witnesses?
The defense rests, Your Honor.
All right. Is the plaintiff prepared to give their closing argument?
Yes, Your Honor.
Go ahead.
Good afternoon, Your Honor, ladies and gentlemen of the jury. Today, you've heard a tragic story of a young girl who is nothing. She is a complete and utter victim today. You've heard from 6 witnesses whose testimonies all show you one thing, and that would be Riley Gardner's negligence and lack of due care. Now, you've heard from Evan Simpson today. Now, let me remind you that Evan Simpson is an inadvertent witness to this case. He doesn't get anything for testifying here today. You heard him say that he is an attentive backseat driver, and he was looking over his friend Joe's shoulder when he saw a silver car go through an intersection going over the speed limit. In this car, he saw a green glow of a cell phone, and never once did he see that driver look up from his lap. He watched that silver car. Well, he saw a car crash, and it smashed into a pole, crushing the right front quadrant. He called the EMS to make sure everything was okay and left the scene. Now, you've heard from Peyton Lancaster today. He is an accredited he's been accredited by the ACRTA in accident reconstruction. Now, he was called 2 days after the accident happened. 2 days is a long time when your job is to figure out what happened that night at the accident site. In order to use the time that he had as effectively as possible, he had a trained engineer with whom he worked closely with go and take the measurements for him. He determined that the car was speeding at least 8 miles per hour over the speed limit. He told you that when someone is driving and texting at the same time, their eyes spend 400% more time off the road than if they weren't texting. Knowing this, Riley Gardner's texting that evening meant that his eyes spent 400% more time off the road than they would have otherwise. This is an enormous amount of negligence on the part of the defense. From Adrian Knight came several other facts. The fact that the front tire is not the cause of the accident. The fact that the only time he talked to Miss Young was when she was on pain medications. She never had a chance to give her side of the story. Now, you heard from Alex Williams today. He was in the car. He claims he knows everything that happened. He claims he saw Sydney take off her seatbelt, but he also says that he was not the seatbelt police. He didn't even pay attention to see whether she put her seatbelt back on. Now, he also says that he saw a shadow run across the road. Let me put on a few things. The road was well lit. The headlights were on. And nobody else testified today that they saw a shadow run across the road. So, this means that either Alex was lying here today when he said he saw this shadow, or that Riley was not paying attention to the road when this shadow went by. Now, last two people that I will refresh you on today are the burglar and the innocent victim of our story. Because of the negligence and lack of due care on Riley's part, Sydney Young will never be able to do what she loved to do. And all Sydney did was accept an invitation to go eat that night. Now, Sydney Young told you that after a party at Austin Kramer's house, Riley Gardner asked her if she wanted to go get some food. And in doing so, Riley took Sydney's life into her hands. On the way there, Riley had been fighting with her boyfriend, Taylor, through a series of texts. Because of this lack of attention to the road, she crashed her car into a pole. The impact was so hard that the passenger's door would not even open. She will testify that the car was going over the speed limit and that Riley had been texting while driving. She told you that she was going to be an artist when she got out of high school. She had won contests with her drawings. She was on the way. She will never be able to do that again because of what Riley Gardner did. She cannot even do simple things as pick up a glass of water right now. Now, you've heard from Riley Gardner tonight. She was the driver that night. She knew when she invited Riley Gardner, or when she invited Sydney Young and Alex Williams to get in the car, that they were drunk. She knew that she was taking their lives into her hands. She knew that it's dangerous to text and drive at the same time. She knew that she was still getting used to her car. She could not even park her car, yet she was willing to take 2 other passengers with her. Now, when asked about the driving laws, Miss Gardner said that she knew them, but yet she didn't follow them. Ladies and gentlemen, ignorance is no excuse for breaking the law. Now, I'm confident that you now see Riley Gardner display negligence and a lack of due care that evening, and is the proximate cause of the plaintiff, Sydney Young's permanent impairment and emotional distress. And you will award her the damages that she is due. Thank you.
All right, defense?
Thank you.
Ladies and gentlemen of the jury, we are gathered here today for you to make a decision. If my client, Riley Gardner, was negligent, as claimed by the plaintiff, and if that negligence was a proximate cause of the plaintiff's injury, or if the plaintiff was negligent, and if her negligence was a proximate cause of her own injury. Let me remind you that the burden of proof is on the plaintiff. They must show by preponderance of the evidence that Riley Gardner not only was negligent while driving, but that her negligence was the proximate cause of the plaintiff's injury. However, should you find that the plaintiff was comparatively negligent, and that her negligence led to her own injury, then you must reduce any monetary relief awarded to the plaintiff accordingly. Let us begin by reviewing the negligence claimed by the plaintiff. First, the plaintiff claims that my client was texting while driving at the time of the crash. True, there was a text sent from Riley's phone just seconds before the accident. But if we take a closer look at the phone record, Exhibit 2, you can see that Riley's texting style is pure abbreviations. The text sent just before 1:12 a.m. on May 12, 2007 uses full words and proper grammar. It is therefore extremely unlikely that Riley Gardner typed it herself. Also consider the fact that all three occupants of the car, Riley, Alex Williams, and the plaintiff, have all said that Riley handed the phone to the plaintiff before the crash took place. Given the different writing style of the last text message, the most logical conclusion is that the plaintiff wrote and sent that message. Additional proof offered by the plaintiff of Riley's alleged texting is the testimony of Evan Simpson. Mr. Simpson had been traveling down Pitts Avenue and claims to have seen a faint green glow in the oncoming car. But in order to see this faint glow, he had to lean forward, around his friend, look down the road past blinding headlights. Ladies and gentlemen, I assume you all drive, so I assume you all realize how impossible it is to see inside an oncoming car at night while its headlights are on. The plaintiff could also claim that my client was drinking on the night of the accident, but the plaintiff only heard about the alleged drinking after the accident. Also, Officer Knight ordered blood tests for both Riley and the plaintiff. Riley's test results showed no alcohol in her bloodstream. The plaintiff's results, however, showed a blood alcohol level of 0.09, which is legally intoxicated in the state of Superior. The plaintiff also claims that my client was speeding at the time of the crash, but according to Officer Knight's calculations, the car was traveling at about 5 miles per hour below the speed limit at the time of the crash. Peyton Lancaster, the accident reconstructionist hired by the plaintiff, would have you believe that Riley was driving at least 43 miles per hour at the onset of the crash. But Mr. Lancaster was never actually at the scene of the accident. He merely went off the pictures and data gathered by the local police. How can we be sure that he interpreted the information correctly, since he was never actually there? Now, according to Superior state law, each driver and front seat passenger of a motor vehicle operated on a street or highway should wear a properly adjusted and fastened safety belt. Also, failure to wear a safety belt may be considered evidence of negligence and may reduce the recovery for damages. The plaintiff wasn't wearing her seatbelt at the time of the crash. Alex testified that the plaintiff took it off to turn around and talk to him. Further proof of this can be found in Officer Knight's accident report, Exhibit 1, which states that the plaintiff was found not wearing any safety equipment. I mentioned to you earlier that the plaintiff had been legally intoxicated at the time of the crash. I am not saying the plaintiff's being intoxicated led to the crash or her being injured. I am saying that the plaintiff's being drunk impaired her judgment, causing her to not think twice about unbuckling her seatbelt to turn around and talk to Alex. It is common sense that sitting properly in a car seat and wearing a seatbelt keeps a person safer during a crash, potentially lessening the degree of injury. Riley and Alex were wearing their seatbelts that night, and they walked away unharmed. Even taking into consideration the fact that it was the plaintiff's portion of the car that hit the utility pole, her wearing a seatbelt could have helped lessen the severity of her injuries. Ladies and gentlemen, no one knows what caused the crash. The front right tire could have blown out. Evan Simpson said the roads were wet. Alex said he saw a big black shadow dart in front of the car. In the end, the cause doesn't matter, because it wasn't Riley's fault. Accidents happen. They just do. Today, my fellow attorneys and I have shown you that the accident that happened on May 12, 2007 was not due to Riley Gardner's negligence. We've also shown you that the plaintiff was comparatively negligent. If you find that the plaintiff was more than 50% negligent, then you must find in favor of the defendant. If you find that she is less than 50% negligent, thank you, Your Honor.
Rebuttal?
There's no time left, 1 second.
For her? Oh. If you can get it done in 1 second, you can go. All right. That concludes the testimony and argument in this case, so the jury and I will retire to the jury room to consider our scoring.
She's wrong. $1 million. Yeah, she's wrong. Good job.
Okay, now comes the time when we get to talk to you about your performance and hopefully something that'll help you in the future as far as if you go on to any other type of competition with regard to this, or even next year, or perhaps even later. I'm going to start again with the sheriff. He's the timekeeper here, and he's going to kind of give you some idea how well you did with your time.
Great job today. I recognize some of the familiar faces coming year after year, and I watch you mature and turn into better witnesses, better plaintiffs, better defendants, and that's heartwarming. Great use of the time. This is the third one I watched today, and everybody really used their time wisely. 11 and a half minutes, 10 minutes, 12 minutes, much more time than what I've watched earlier today. You have a tremendous amount of time when you're asking questions, and there's no race when you're in that chair. I know you want to get out of there as quick as you can, but you've got all day. 25 minutes and 20 minutes is a long time. Shelby, the closing was 4 minutes and 59 seconds. You were this close to being done. That's a great use of your time. In the real world, they don't time you. So that's a great use of your time. So it's encouraging to me to see the best of the best do this year after year. So good luck when you run your next levels. I hope if you all become attorneys, you're prosecutors, so you don't beat up my deputies.
All right, Mr. Davis.
It's a tough job, writing down the scores for all of you. I thought this group was just outstanding. There wasn't a bad witness here. I mean, you all got into your roles. You paid attention to the questions. That's one of the hard things to do. I know when you have a script and you have to sort of follow it, and sometimes it's easy to get thrown off or trying to be thinking about what you're going to say. But you all paid attention to the questions being asked of you and responded very well. You got into character very well, Ms. Plaintiff. That's why I can remember all your names, and they take away our score sheet, so I can't call you by name. And that's a really important part of this competition, I think, is because there's so much attention paid to the attorneys who are representing the plaintiff and the defendant, but the witnesses have a very important role too in convincing the mock jury, whether there really should be an award or not. All of your questions are really good, so I'm not going to dwell on your techniques and so forth, but the opening statements were really great. You did a wonderful, wonderful job. Eye contact was excellent. You talked right to us. You were very emphatic and forceful, laid everything out. You got all your elements in very well, burden of proof, all those things. Some things we didn't see in some of the earlier competitions, so that stood out. And your closing argument also was very outstanding. Don't worry that you ran out of time, because we knew you were right there, so, And I was kind of worried because earlier on, when you had talked about the comparative negligence, which was a good point, I thought you'd kind of forgotten about the 50, but you came right back to it at the end and wrapped it up very neatly. So that's a really good thing when you can, because the plaintiff, first you have to show that the defendant screwed up, and then also that was the cause of these injuries, and there were injuries. And sometimes one side gets glossed over more than the other, but you did a good balancing there of doing that. And likewise, for the defendants, showing both that that she wasn't really at fault, and even if she was, the plaintiff's fault, the plaintiff's negligence contributed to it. The one thing I was kind of looking forward to, I never saw in any one of the competitions today, was when we were reading through the materials, the comment that one of the witnesses said that as far as being an artist, she probably would have been a starving artist. I was kind of disappointed. Nobody kind of got on that and said, because that would go to the element of damages. Well, okay, she wanted to be a cartoonist, but so what? Would she have been successful at it? That might have been something to throw in, so for what that's worth. So again, really good job. I was very entertained and glad I spent my day here. Thanks.
Mr. Keyes.
Thank you, Your Honor. You're all very skilled advocates, and you're all very skilled witnesses. These were two excellent teams. I know that because during your presentation, I found myself thinking more about the evidence and who was presenting what, as opposed to your skills. So the fact that I wasn't thinking so much about your skills is a testament to how well you really did. I was very impressed with the fact that everybody had a very cohesive approach and everybody listened to the testimony that was being presented. And witnesses, you were all very compelling in what you did. I also want to point out a couple things that, and I only say this, and I only say this because you did such a wonderful job. I just want to point out a couple things I would do differently in the future. Colby, you're very good at what you do, but you also cannot be so reactive at the table. I knew when you made an objection that you got up and you made the objection, like, why did I make that objection? You gave the sense to the jury that you had made a mistake. With your skills, make us believe that that was not a mistake, because the jury's not going to know. You know, we as attorneys know, of course, but you have to convince the jury that you knew what you were doing. So that's something to think about in the future, okay? Sarah, Colby had just done a great job on cross-examination, and first I would have loved you to get up there and try to help your witness out who just got taken apart. And so I really would have liked you to get back up there and try to rehabilitate your witness a little bit. But you didn't, and that's okay, because there are times that that's not a good idea either. So that was number one, but he sat down and you told him, great job. You can do that when this is done. Don't give the jury the impression that the attorney just took apart your witness. So that's something to think about in the future.
At least it was impressive.
That's very true. It's an excellent job with your cross-examination, excellent job with your closing, excellent job with all of the examinations. I really enjoyed that. That was terrific.
Ms. Lane?
Thank you. I would join in many of the comments that have already been made. I'm assuming that most, if not all of you, are going to move on to other aspects of the competition at another level. I would just suggest you keep a couple of things in mind for future reference. Continue to take your time and do not be in a hurry. When you have the benefit of witness statements, as you do here, make sure you get as much out of that witness as possible. Remember, just about every fact is in there for a reason. So look at every piece of information you're given, and if something looks like it's just fluff, it may not be. There may be a way you can use that to your advantage, either on direct examination or on cross-examination. So that's a little food for thought from the future, because you could probably get a lot more out of these facts and out of your witnesses than you already have. And now that you've been through this once, you can perhaps look at it in a new and a different light. Secondly, continue to wrap things up, tie things together as well as you have. That's very good. That's very effective in your presentation, because it helps your judges get a feeling that you have a full understanding of the case and that you're very well prepared. So keep up the good work.
Mr. Strummers?
Thank you, Judge. I took notes throughout, and I thought you guys did a really good job. You were really well prepared, which I appreciate, because you can see now how hard it is to prepare for a case. It takes a lot of time. So I congratulate you on that. I think these two teams are good enough to go on to regionals and move up the chain, because I think both your teams are good enough to do that. I really do. And you may. I hope you both do. I'll start with the closing first. Don't worry about getting cut off at closing. I know Sheriff Donovan probably doesn't know this yet, but Judge Cooley now is timing us on our closings, and he sets his clock for 20 minutes, and he says, go. And if we're not, he makes us sit down. But you handled it nicely. The time was over, and you sat down. That was okay. The other techniques that I noticed from an attorney standpoint were very good. Shelby used a very good technique that I think is very important, and it goes to how prepared you guys were. You would actually repeat the answer of the witness that was an answer that was hurting that witness. So the jury hears it 2 and 3 times. So you were drunk, correct? And blah, blah, blah. That's a very good technique. That's a technique that just lawyers learn in law school, not in high school. So I thought that was a very, very nice exchange. The other exchange with Cassandra, you were killing that police officer witness. and they're good witnesses. The police are always great witnesses. They usually learn because they come and they get, they testify a lot and they know what they're doing and they stick to the facts. They're very good witnesses. You're killing. But you did a nice job of saying, objection. And you found a good objection, even though the judge overruled it. The real objection is, Judge, she's killing me. Sometimes you have to object just to stop the flow, and you had a good objection. So I thought that exchange was very, very interesting. I congratulate you. A couple things you want to watch, because I want you guys to go on. The opening and closings are very good. Be careful. A couple of you are looking down here. Look at the jurors. Keep looking up at us. A couple of people kept looking down at the floor. And don't put your hands in your pockets. I can't tell you how many times I got yelled at as a young attorney for standing in front of the judge like this. So don't do that. Make sure you keep your hands down and don't be too animated. But other than that, I really had no criticisms. You guys did a great job.
Ms. Armstrong.
Thank you, Your Honor. Okay, everybody take a breath with me. It's all done for today anyway. And you guys did a phenomenal job. What a great way to end the day. Two great teams that went at it hard, and you did just a phenomenal job. The preparation and the amount of work and the teamwork, which is something that, we haven't seen in some of the earlier rounds, but you take a witness, you take opening, you take closing, and everybody kind of goes off to their corners and gets ready, and you didn't do that. You obviously all worked together to make sure that your opening took into account what this person was going to be bringing out and vice versa. So that's very obvious, and there's so much that I want to tell you about what was great, but I know, number one, we all want to get out of here, and number two, just like the other judges have said, we want you to go on to regionals, we want you to represent our area and just do the phenomenal job that you've been doing. So we want to give you just a little bit of advice to perhaps take with you. It's interesting, what I wrote down was never let them see you sweat, Colby, because I think at one point you lost an objection or something, you went, oh. And you know what, sometimes you're going to lose objections, and sometimes you're going to win them, and you really kind of have to have the same demeanor no matter what happens. And sometimes the judges make a mistake, even if you think, or it just doesn't go the way you thought it was going to go. And so you don't want the jury to think, oh my gosh, I think his case just got torpedoed by that one objection, because that's the impression it gives people, is like, oh, he really didn't expect that. And you want this jury to know that no matter how this evidence comes out, you're confident in what you're presenting to them. So nobody used the diagram, and I know there was a lot with the police report that you were trying to get out. Don't be afraid to use that diagram. You would have been, I think, permitted to walk over there and use that if you needed to. So when you have those types of exhibits and it's blown up for you, if you need that to make a point, Cassandra, you made a great point. In fact, you did great with using, like we said, that officer to make, not just to attack credibility, but to make points you needed for your own case. Like, you said it was dry and level, right? Well, it wasn't dry and level. So, that was critical, and going over and highlighting and using the diagram to make points can be very helpful. One thing I would caution, Matt, everybody did a wonderful job. You have a low voice, and it's hard to hear you, I think, because, sometimes in this kind of setting you forget when you're talking to a witness and they're 2 feet away from you, it's like you're talking to your friend, in the hallway at school, and these people back here and the jurors and other people can't hear you. So that's why I think the judge said something, and you want to make sure you project your voice. Even though you're talking to that person, you're really talking to everybody else too, so they all need to hear you. And make sure when you go over to the witness, because the judge gave you permission to do that, that you don't stand in between the jury and the witness. You want to stand off to the side so that everybody can still see what that person's doing and saying, okay? Really, this was very entertaining. You guys just did great. The points that were brought out and the way that you did it was phenomenal. Keep up the good work, and good luck.
Thank you, judges. Now, I want to say that I don't know any of you, but I'm proud of all of you. I think you all did an excellent job here. I want to point out one thing. It's for the benefit, and it's a rule, okay? When I ask the witness Sydney Young, and I don't have your name here in front of me, so I'm sorry about that, to raise your right hand, you said I couldn't. And the rule, stipulation 8 on page 41 says prohibits the portrayal of any physical symptoms. So if you go on to regionals, that's liable to be held against you. So instead of acting like I can't do it, can I raise my left hand, raise your right hand. You don't want to have that held against you because it's a rule violation. And if it had been objected to as an unfair extrapolation, I would have had to sustain it. Starting with the opening statements, Colby and Ann, you both did an excellent job. Colby, I would recommend that you might want to hit the injuries a little bit more and the effect that the accident had on what you're going to prove as it relates to that, because like Mr. Davidson said here, it's a two-pronged approach. I mean, you have to prove the negligence, but you also have to prove the damages. And so if you spend all your time talking about the negligence, well then you haven't shown a recovery for your client because the jury doesn't know, doesn't have anything to base it on. They can say, okay, it's nominal damages because I haven't had any proof of what this has caused harm to my client. So you want to talk about what you're going to prove as far as what the damages are. What did this do to her? And what you're going to prove as it relates to that. And you started out a little nervous, but I think once you hit the, going on that, you just did you settled down and you went right at it, and you did an excellent job. Let's see. Sarah had an objection to the witness leading questions, and the response was, well, it called for a yes or no answer. Well, really, that doesn't mean that it's not leading. It's just that, in my view, that particular question was not leading, but the next one was, and you didn't object to it. So don't let the fact that I overruled an objection stop you from objecting the next time. Don't be afraid that I might overrule it again. If you've got a legitimate objection, stand up and object. So that happens a lot in these. I'll overrule an objection, particularly on a question like leading questions. Then the lawyer will keep asking leading questions, even though that one wasn't, and it is objectionable. And then because I overruled it, I think sometimes you're afraid to stand up and say objection again. Don't be afraid to do that. Just because it calls for a yes or no answer does not mean that it's not leading. Cassandra did a good job of bringing out the injuries and its effect on her. I think you did an excellent job as a witness that way, and even though you didn't raise your right hand. Matt I think you allowed the witness to answer a question with a question. He did that a couple of times on you. You'd ask a question and he would say, well, what if you did this? Or something, he would ask a question back to you. That's not his role. So what you have to do is ask me to direct the witness to answer your question with a statement, not another question. So you can't answer a question with a question. Don't be afraid to ask the judge to assist you if the witness is not answering a question. So, you want to be careful with that. The testimony about the expert regarding his study of texting, he wasn't qualified, stipulated to as an expert other than as an accident reconstructionist. You have to lay a foundation for his ability to give any opinion testimony with regard to anything else other than that, and it wasn't done. So the objection could have been, it's beyond the scope of his expertise, and the foundation hasn't been laid for the opinion testimony. So nobody objected to that. You might want to consider that in the future. Riley testified right after, and this is the first time in all three trials that we had today where somebody actually brought this point out. The testimony was right after I handed Sydney the phone, I got into the accident. Now I think that's an important thing. And I've been pointing that out all around here because now you've got that tied in. He says right after this, the same thing, Sydney testified the exact same way. He tossed me the thing and right after that we got into the accident. Well, if you look at the exhibit with regard to the phone text messages, it's a minute and a half between the time that Riley says, no text while driving, and the last text. So if he's going to stand by the fact that he got into an accident right away, I think that's an argument to the committee, in closing argument, that he was texting the whole time. Because both of those witnesses said he tossed it to me, or tossed it in the air, and we got into an accident right after that. So there was no time to do anything other than that. So if, in fact, that was true, then he had to have been texting the whole time. I think that's an important part that was missed by pretty much a lot of people today. The seatbelt police, again, first time somebody brought that up. I think that was very good. You might have asked another question with regard to that, because he specifically said, I did not see whether or not he had his seatbelt on because I'm not the seatbelt police. And then later he said he didn't have the seatbelt on. So, you can't have it both ways, and I think I would have brought the fact that he specifically said I don't know whether he had the seatbelt on or not, out. The fact that he was drinking was objected to. The objection was a good objection, by the way, because whether it's relevant or not, whether he brought the beer to the party, who cares? What's relevant is whether he was drinking it. But it was really kind of a minor issue, so I just let it go on that. I mean, it was a good objection, but I just let it go because the next question obviously was going to be that. Questions about the officer, I already mentioned that. Cassandra, you did a terrific job at cross-examination. I really believe that you nailed that. And I agree with Mr. Stremage. The objection is you're killing me. You just did a very good job, and you hit it. And the problem was, when there was an objection about the one question you were leading up as to all the things that were on the exhibit here, the length of the skid marks, the going over the curb and all of that, and then when they had an objection, and I overruled the objection, it allowed you to repeat it all over again, which hammered it down twice. So you have to be careful about the objections on there, because if you lose that objection, that gives the jury another opportunity to hear it. And it's bad enough coming out the first time. You don't necessarily want to have it hit twice. And like Ms. Armstrong said, I think you should have gone to the board and pointed out, because the witness that you were talking about was the one who drew that diagram, and you got that whole length of skid marks that he didn't bother measuring. You could have used that diagram during that cross-examination, but you did an excellent job with it. And Shelby and Sarah, you nailed your closing arguments. You really did, both of you. As I indicated before, I think you all did an excellent job. I'm proud of the effort that you've put in here, and I think you should be proud of it yourself. Good luck to you if you go on to the next round, and I guess it's time to quit. So we're adjourned.